All right, everybody. So welcome to the webinar. My name is Sarah Grillo, and today's webinar is the new SEC marketing rule, what you need to know. And I'm going to just go ahead and get started. We have a lot here on the docket, and we told people we would be starting at this time. So too bad for them if they are late. And before we get started, I just wanted to go over some boring disclaimers. This webinar is being recorded. If you cannot be on a webinar that is recorded, then please exit the webinar and I'll send you the replay. The other thing is, I just want to be very clear that nothing in these materials can be interpreted as legal or compliance advice specific to any one individual or firm or situation. For such legal or compliance advice that is specific to you, please consult a legal advisor. There's nothing to say that this information will be, I will strive to maintain current information, but I am under no obligation to advise people if the statements made in this were to change in the future. And having voiced those boring disclaimers, let me move on to the show. So who are we? Well, I am Sarah Grillo. People know me as the leopard of LinkedIn marketing for financial advisors. And I've got three very skilled experts here. I will go ahead and just let them introduce themselves briefly. Richard Chen. Richard, let's get started with you. Who are you, Richard?
Hi. Well, thanks for having me, Sarah. I am a practicing attorney. I've been in investment management for nearly 2 decades. I own my own law firm practice called Richard L. Chen, PLLC, which provides legal and compliance services for investment advisors.
Great. John.Ivan.
Hi, everybody. Good afternoon. I'm the little bit of the Debbie Downer on this because I am over 35 years in compliance, primarily for dual registrants and a lot of wealth management teams that have now made the leap to independent RIAs. So I will be the one saying yes, but, yes, but, yes, but I have dealt with each and all of these issues and some of the frustration that everyone on the webcast has had with the former rules.
So you're the yes, but person on the webinar.
Yes.
The ellipsis, ... Okay, John. And Andrew.Lippman. What's up, Andrew?
Hi, I'm a colleague of John's over Capital Forensics, and I have over 35 years experience in the brokerage industry. And I'm neither a lawyer nor compliance. I am helping people operationalize and solve problems. And I've been working more and more on legal and regulatory issues because, as we all know, that's the way the whole industry's been heading, is much more attention to that.
All right. So now, before we get into it here, I just wanted to let you all know that there will be a replay of this webinar. And if you would like the replay, please go ahead and just make sure that you're signed up for my newsletter. If you're already getting my newsletters, there's no need to sign up again. And by the way, thank you for supporting my content. But if you are not already subscribed to my newsletter, please visit www.sarahgrillo.com. Sign up for the newsletter, and Sarah G is your girl, won't let you down. You'll love the newsletters anyways. All right, so now, next, let's get on with the show. At a high level, folks, what is the new SEC marketing rule? Break it down, gentlemen.
All right. Well, let's talk about something that's exciting a lot of advisors. The marketing rule is revamping of existing advisors' advertising and cash solicitation rules that have been long overdue for an upgrade. So what does it do? I think that advisors are most excited because now there are opportunities to do things you couldn't do in the past, namely provide testimonials from clients and endorsements about an advisor from other people other than clients. It actually also reduces some other sort of obligations when it comes to cash solicitation, but it's an overhaul, and it's a significant overhaul that will require a lot of work to make sure a firm comes into compliance.
And I would add again, I'm the yes but guy. And I would add again, this is an SEC rule. So remember, are you SEC registered? Richard can walk you all through that. Or are you state registered? And then unfortunately, as a number of you know, the states still have their finger in the pie a little bit, and we'll talk about it, especially on some of the solicitor parts. So whereas there's a lot of good news, to Sarah's warning that things can change in general, things can really change with this. And you know, you can, Richard will walk through how you can go effective. The SEC actually just put out a little warning about going effective. You want to walk through that, Richard?
Absolutely. Yeah. So the rule, excitingly, is effective as of today. So technically, if an SEC registered firm wants to adopt the marketing rule, you can do that as of today. The compliance date, which is 18 months from now, i.e. November 4th, 2022, is the date when you have to comply with the new rule. Anytime an advisor wants to between now and then, it can come into compliance. The catch is, as John said, you have to come into full compliance, which for the vast majority of SEC registered firms will entail a lot of work reviewing existing policies and procedures, your existing marketing materials, and making sure you have operational procedures to ensure compliance with the new rule.
So we all know about cherry picking under the rules. You can't cherry pick and say, oh, I want to run out with that testimonial tomorrow, and not be in compliance with the rest of the rules.
That's right. Yeah, exactly. We'll walk through some of the specific opportunities and risks on the specific, the sections of the rule that are most relevant for advisors throughout the rest of the podcast.
Okay, so here are the 5 important areas to be aware of: testimonials, cash solicitations, moving to a principles-based approach, performance advertising, and entanglement and adoption. There are 5 of them. We're going to start with number 1, testimonials. Let's get it started, guys.
All right. So testimonials, I think this is the thing that most advisors are most excited about, because in the past, the old advertising rule said that in the vast majority of circumstances, you could not provide testimonials from your clients or endorsements from others about your firm, because it was considered to be misleading, because it didn't give a balanced approach as to what a client could expect from your firm. Now the SEC has said testimonials and endorsements are permitted. They do constitute advertisements, even if they're in one-on-one presentations. And there are, however, a number of requirements which John will tackle relating to the conditions that the SEC has put in place if you want to use testimonials and endorsements.
Right. So as everything, good news, bad news, they actually kind of squished together the testimonial and the cash solicitation rule. And kind of the first big point, and we'll talk a lot about what because you're probably used to the old rules where everybody said you have to do this and have to do that. So we'll try to highlight some of those things. But in addition to just being, you're actually let into the arena now. We can actually get into this arena. It has to be. You can have a testimonial. You can still have solicitation, and there's, as I said, they're all now considered sort of one thing. And again, you have to understand it's SEC still is fair based and a disclosure oriented sort of organization. So the testimonial is now not prohibited, but you have to meet some requirements. First of all, if you're going to pay for that testimonial, that's a big one, right, Richard? That's a big first V in the road. Are you going to pay somebody to give that testimonial? And then do you have to have an agreement in place, and at what level? And The SEC recognizes all payments aren't equal. They want to, there's going to be more stringent, depending on how if you're paying for that, and you can understand why. And then you have to have lots of disclosures about the fairness of it, and it has to be, it has to start with being a fair testimonial or endorsement, and then you'll build the rules around that. And instead of being a dead set no, it is yes if it's fair, and if there is some and to make sure that there's disclosures, prominent disclosures everywhere. And Richard, you can talk about prominent disclosures, that so somebody actually knows what's going on with this testimonial, and hopefully there's skilled people that can still make it effective. So
yeah,
that's kind of the framework of, you're going to have some disclosure requirements, some agreement requirements, and they kind of ratchet up depending on how much you're paying and things like that. Richard?
Yeah, let's talk about the disclosure requirements. You don't have to name the person providing the testimony endorsement, but you have to indicate whether they're a client or someone else, so they have a relationship perspective in terms of the advisor. If there's any compensation paid, it has to indicate prominently that there is compensation paid, and the conflicts of interest that are associated with it. However, the additional disclosures about the specificity of the compensation and the specificity of the conflicts are also required to be disclosed, but they can be not clearly and prominently located, i.e. you can put them in a footnote and put them in the back or something, but the other ones have to be prominently and clearly disclosed. The other important requirement is that you have to have a reasonable belief that the testimonial or endorsement is actually accurate. So it requires making sure that, or at least kicking the tires to make sure that it's not an outlandish statement that isn't true, because an advisor will be held responsible for it.
Okay, can we move on to the cash solicitation rule?
Yes, let's do that.
Okay.
So John, yeah.
Before I do that, can I just pause here for questions? Folks, chat in your questions if you have any questions on testimonials. I'm just going to give people a minute before we move on to point number 2. Okay, I want this webinar to be interactive.
While people are just putting in their questions, the idea about disclosures, one important part, as it is for all disclosures, is not just to have the disclosure, but to consistently have the disclosure. And that's not just an SEC marketing rule, of course. And that's a real challenge, to make sure that your documentation is consistent throughout, and that you're not using similar documents in different places with varying degrees of the disclosure, which can then create conflicts between them.
Yeah, another challenge will be social media platforms, where it'll be hard sometimes to put clear and prominent disclosures where you have limited character space. So people have to navigate that challenge too.
Okay, folks, so we have our first question. The question is, where can we find these testimonial rules in writing? Full or summary? Excellent question. And please, folks, keep those questions coming into the chat box.
So Richard will have a great blog up on his website. So a lot of law firms will have lots of good summaries. So kind of pick your favorite law firm, pick Richard. There'll be some nice summaries there. The official, what is it, Richard, 433 pages? It is an actual SEC release, and we will provide that to Sarah, so everybody can actually have it and have the fun of reading that.
Yes.
Fun with a capital F. Well, good that you're all reading it, because I ain't gonna. Sure as heck no. All right, folks. So it looks like, let me see here. Okay, another question. What is the best way to track what my state is doing in terms of this guidance. Should I just call, or do states update their websites with guidance? Excellent question. Thank you again, folks. More questions, please. Keep going. What's the
Yeah,
next?
that was that actually that question actually stole our thunder, and is probably why this is probably the best webcast you'll have on it, because if you go down the road saying the SEC said this and I'm home free, then that questioner got it exactly right. There's two as I talked about earlier, there's two parts to this question. One is, are you an SEC registered investment advisor? And then two is, wait a minute, the states had a lot of things up there about solicitors, which we haven't quite got to, or advertising. So Richard, you want to go into that?
Yeah, so the challenge is that even as a SEC registered firm, if you have folks that are soliciting for you, they could still be subject to state regulation. And I think that this is what the person posting the question is getting at. Those state regulations, unfortunately, haven't been updated to make their state rules comport with what's in the SEC marketing rule. And so it's important to keep track of those requirements, because those could be applicable to those who, who provide client referrals to your firms. The problem is there's no central location for those. You can go to the North American Securities Administrators Association, and I think that they have broad links to the securities regulator websites for the various states, but unfortunately, there's no central location to find all of the securities acts of the various states.
Yeah, no, that's absolutely true. I was actually just in a matter where people were going, I don't see that anywhere. And I said to the questioner's exact point, well, you didn't call the state, because a lot of times you actually just have to call the state, and they're actually pretty good. Once you kind of get through a normal bureaucracy and a normal disaster of a telephone call in to anything, once you get to the securities person talking, they're pretty good at getting you to usually an attorney that will be thinking about this guidance right now.
Okay, so one more question on this point, and then we're going to move on to point number 2. Do you expect either NAASA, so I want to say NASA, but this is by no means as fun as the astronomy NASA, okay, or Uniform Code Commission to release recommendations for new state rules that could be more or less uniformly adopted?
I haven't seen anything specifically focused on that. It very well could come down the road, but I don't foresee anything in the short term.
Now, Richard and I were actually just talking about this the other day, and we noticed from their comment letter, in other words, when the rule is proposed, NASA put in a 15-page comment letter and said, we kind of like this, we kind of like that, and we really like this, and we really like that. Unfortunately, about 4 of the things that they really liked, the SEC didn't do. So they, we just haven't heard from an organization yet on how they're responding. And of course, we know that some state regulators just march to their own drum. And if you're in Massachusetts, or you're in Florida, or you're in Alabama, you know exactly what I'm talking about.
Okay, the cash solicitation rule, number 2.
Yeah.
So that was a trick for everybody, right? Everybody says the cash solicitation rule. Well, the big change in the SEC rule is it's no longer just cash. It is cash or non-cash solicitation. So with that, I'll turn it over to Richard.
Yeah, so as John said, there are certain requirements if you receive cash or non-cash compensation for a testimonial or endorsement. Namely, the old requirements related to cash solicitation that you had to get a written agreement with the person providing the referral to you, and that person has to provide a disclosure document indicating what they get paid and the conflicts of interest they face. That has to be provided. Now it's regardless of whether you're providing cash or non-cash compensation. The good news is that the SEC carved out those trends, those arrangements where a person is receiving less than $1,000 in value in cash or non-cash compensation. So now if your clients want to provide a referral and you give them a token gift, you don't have to be subject to the written agreement disclosure requirement, that they have to get a separate disclosure document. The other requirement is that you have to make sure that folks who provide client referrals to you for compensation are not statutorily disqualified, meaning they were sanctioned by a regulatory authority like the SEC, or they were subject to a criminal conviction.
And remember, pay attention to the fine print on that $1,000. That's annual. So if you're 300, 300, 500, oops, now you're over it. So it's a chief compliance officer's dream to try to have a new rule to keep up with that.
That's a great point, John.
And again, this is one where that again, as Richard already said, this is one where you got to look at the state as well, because many states actually, amazingly enough, actually require solicitors to be registered, and some of them even with the investment advisor, which makes for some really interesting registration talks with the registration groups about how do we register somebody who we don't even know anything about them.
Got some questions on the chat here. Is that $1,000 per person endorsing or per firm for all endorsements? Is that $1,000 per person endorsing or per firm for all endorsements?
Well, so it depends. It really comes down to who is actually making the endorsement. Is it the firm or the individual, right? So now I will say this, that the Advisors Act has a anti-circumvention or a provision where basically if they catch you doing something indirectly and trying to be cute, they will consider it a violation in any event, right? So so arrangements that are structured to avoid this requirement will be seen through.
Another question. Do you think RIAs will need to follow home office state rules or the state where the client lives, or both?
That is a complicated question because it really depends on the state rules. Some states will govern advisor registration and regulation issues based on if the advisor has a place of business in the state. Some purely look at the residence of clients and whether you have clients in their state. So there's unfortunately, all the states have differing rules in that respect.
And I always, you want a good lawyer like Richard to give you that answer, and then just practically, where if something goes wrong, where's the client going to complain? And if they're going to complain where they are, for the most part they're going to complain where they are. So you need to factor that in as well. So you can sometimes, and then of course, like here in the tri-state, you're always worried about, oh, we got people commuting, clients are commuting, advisors are commuting, everybody's commuting. So we always practically sort of said, well, we're going to make sure we know the whole tri-state and make sure we're not tripping up on a big issue in the tri-state.
And that's going to be an issue going forward, depending on where people consider you to be based when you're remote. You're working half the time in another state. So we have yet to see how the states are going to tackle that.
Okay, I'm moving on to point number 3 now, principle-based approach.
Right. So this one's interesting because we're moving away from rules-based approach in terms of advertisements where we prohibited testimonials, we prohibited you from providing specific references to past specific profitable recommendations. And now there are principles, 7 general principles. I'll sort of put the general categories out there. The first is don't provide misleading or false information. The second is if you're providing material facts in any communication that's considered an advertisement, make sure you can support and substantiate that when the staff asks you to. And the third, which is probably the bulk of the principles, is, as John said before, we need to make sure that presentations are fair and balanced. Now, this can be a challenge in some areas, notably with respect to testimonials. You know, the staff has said, yeah, okay, we don't require you to provide an equal number of favorable and unfavorable testimonials or endorsements, but you have to provide a representative sample, or at least link to a representative sample. It is not sufficient to provide a disclosure that says, these are not representative of all of our testimonials and endorsements. Simply having a disclosure and disclaiming that away will no longer be sufficient.
Yeah, moving along, they're all just mom and apple pie, all 7 of them. You want the fair and balanced, and fair and balanced always means fair and balanced about the risks and limitations. So things can, this is performance and testimonials. So always think making a nice effective disclosure, a prominent disclosure where appropriate, and the additional disclosures, and then just common sense. Is it fair and balanced? Remembering the things that the SEC really doesn't like, when you haven't substantiated anything, when it looks like you're cherry picking and things like that. And then some additional guiding principles that get into performance specifically. So we're kind of migrating to our 4th point as well. There's some really important points about certain things that we've always wanted to do, or could we do it with performance? And I think we'll hold that for a minute.
And just one general comment with the whole trend towards principle-based approach. It's sort of be careful what you ask for, you may get it, where in the past, everything was sort of rules-based, and now the trend has been towards principles-based. And principles-based is tricky because it's not got those firm guardrails. And that's where you really need to have some objective opinions to help you understand if it really is principles-based. And someone like a Richard or John with Capital Forensics can help with that, because it's often hard to know what a principle-based approach is when you're looking internally.
Yeah, it's like there's always an old lawyer's joke. How do you know obscenity? I know it when I see it. That's kind of how the SEC will probably look at this, right? Is it look fair and balanced? Maybe not. And so the challenge is really making sure that, as Andrew and John said, that you really try to look at it objectively.
There's another question in the chat box. And by the way, folks, if you have questions, make sure that you're chatting them in. Are sample templates or illustrations available?
They're absolutely going to be, depending on who you call and how quick they are in getting these developed. So if you call us, we'll let you know how we are, and you can call Richard, he'll let you know how we are. The SEC did not, sometimes they do, right, Richard? Sometimes they will actually put some out. Now, some of their words actually get to a template, like the 5, 10, if you want to go over that one, Richard, some things are actually in the rule, but on some rules, the SEC will actually say, hey, here's a template, like they did with the Form CRS for Reg BI. They said, here's at least in the proposal they said, hey, here's one that you might want to start with. But they did not on this, as far as I've seen.
Yeah, they very well might, but I think because advertising is so specific to firms, they very well may not. And this is a challenge for a lot of folks, because it'd be nice to have a baseline to work with. And I think that invariably you will start to see folks who put out advertising that has these disclosures, and you can look at that and figure out whether or not those are a good place to start. But then you really need to customize it, because they'll definitely be looking for that.
Yep, absolutely nothing worse than a grabbing a template and not customizing it, and keeping in a couple things that don't even apply to what you're using it for. Want to talk about performance, or we got more questions?
Yeah.
Sarah?
Okay, there's a few questions actually in the chat
Okay.
box. And these are just real quick. Will the presenter's contact information be made available as well as the presentation? And then someone's asking, are we going to get the replay link in the newsletter? So folks, I'm actually going to chat out here my website. If you haven't joined my newsletter list, please join the newsletter, because this replay is going to go out in the newsletter. Yes. The presenter's contact information, presenters, you can enter it right into the chat box if you'd like. And also we can put it up at the end of the presentation, and we can also email it out with the replay.
Andrew will do that for me. If I try to start entering something, the lights will go off on this presentation.
Yeah, I'm with John.
And Richard, I'll enter yours as well.
Sure, thanks. I appreciate it, Andrew.
Yep, sure.
So performance advertising, I'm going lots of new and exciting things in here, but to kind of carry over from the general principles which apply to this as well. Substantiation, unfortunately, that substantiating your performance and those actual books and records of performance, if you're trying to bring your performance over from another firm, they're still there. They didn't go away, right, Richard?
Yeah, that's right. Yeah, and so there are a couple sort of specific things in performance that are interesting. Let's start with the good news. They seem to have relaxed a little bit the frowning upon hypothetical performance that they used to restrict. It seems to be a bit more open. I think that there's still a general frowning upon providing in a mass publication, but there's more flexibility in providing hypothetical performance, provided that appropriate disclosures and assumptions are provided. On the more negative side, especially for some private fund sponsors, is that they've eliminated some of the flexibility in providing only gross performance results. Now, if you present gross performance results, they have to be presented side by side with net performance results, and those exemptions seem to have gone away. The third specific thing is that they seem to want to have a more apples to apples comparison in terms of presentation performance. So now what they'll require is that firms put out a 1-year, 5-year, and a 10-year presentation performance results. Now, obviously, if your firm hasn't been around 10 years, they'll require it as long as it's been around. For instance, if your firm's been around 7 years, then you'll do a 1, 5, and 7-year performance track record, so that firms aren't putting out something that's too narrow and perhaps cherry picked. This will provide a bit more of an apples to apples comparison.
Yeah, I think it was very helpful to see, especially in this area, the SEC, understanding that a lot of times you're actually requested, how would you have performed in that market? That's actually comes up a lot, and so there's a lot of ways you can work with your counsel and your compliance or whatever. There's a lot of ways, because I think the SEC is recognizing that and certain unsolicited requests are not even in, they're actually carved out of the rules. So there's ways to, it was refreshing to see that there's ways to actually deal with a lot of commonplace requests that actually come up. And there still is hope for that one-on-one, sit down with a very sophisticated person about about a private fund, whereas you do have to, or you do need to have net with it. I guess maybe that's the bad news, but some of the other rules don't apply to those one-on-one scenarios.
And Richard, maybe you could speak to this. Besides, if your firm has only been around for 7 years and you do 1, 5, and 7 or something, but if you've been around for 20 years, but your firm has only been around for 7 years, then the blurring of the line between your sort of historic performance versus your firm's historic performance?
Yeah, that's a great one. So what they've done is there used to be informal guidance regarding performance portability, right? And that informal guidance has now been put into the rule. Effectively, they want to make sure that if you were an individual at a prior firm, that are the same people making the decisions, right? Is the strategy the same? I.e., is this still an apples to apples comparison, or is it so different, right, in terms of people who are making decisions on investment strategy, that it's really not an apples to apples comparison? Provided that it makes sense and it is an apples to apples comparison and there are appropriate disclosures, the SEC is okay with prior performance track record.
As long as you have the records.
That's very important. And that goes,
sorry, Debbie Downer had to jump in again.
Yeah,
as long as you
that's
have
a
the records,
really
and
great
that's been a deal killer, unfortunately, because a lot of time, as you're transitioning, you want to really think about that.
And that holds true regardless of definitely, specifically when porting over performance from a prior firm where you might not be able to get that track record. It holds true for all the performance advertising where the SEC really will scrutinize whether or not you have the supporting calculations in order to support, and the worksheets to support the presentation of performance results you're presenting.
And I should just mention that Capital Forensics maintains the broker protocol information. So if you have questions about that and how it relates to this, give us a shout and we can talk you through some of that, as can Richard, I'm sure.
So any questions, sir? We're ready?
What is the likelihood that advisors who use TAMPs be able to implement these strategies? That might be a stretch and mitigate the availability of need info.
I'm not sure I understand the question. Is it referring to whether third-party managers that are on the TAMPs, you can utilize their, sort of present their track record? I'm not sure you quite understand the question.
Okay, the person says yes to that.
Okay.
You just said, Richard.
Okay, so this is not related to the marketing rule, but it is a challenge because there was an enforcement action a few years back where an advisor was held responsible for a firm that blew up called F Squared, where the SEC surprisingly and unfortunately felt like the advisor should have been responsible for vetting the F Squared performance results that were presented by the advisor. It is definitely an area of concern. I don't think it's necessarily something specific to the marketing rule here because it's third-party presentation. I guess technically it could. We have one topic to discuss, which is adoption entanglement, but I think that it's a separate issue. It is unfortunately a concern. The SEC seemingly does expect you to have some reasonable basis for believing that the underlying performance results from a third-party manager are genuine. Of course, I don't know exactly how you would be able to verify that in most cases.
Yeah, and this is a tough week to in memory of Bernie Madoff. There's a lot of third-party intermediary managers who were not obviously getting their arms around that. So just keep that in mind. But entanglement and adoption actually is kind of almost the reverse of this and does touch on it, Richard.
Yeah, so why don't we touch on that? So the advertising rule says that you're responsible for communications directly and indirectly about your firm, right? And so technically the SEC has said now that if you're involved with a third party's communication about your firm, you could be held responsible in certain circumstances. For instance, if you were involved in preparing those materials or you had some input in how those materials come out, even if they're generated by a third party, they consider you to be quote unquote entangled with those materials. If you, on the other hand, adopt, endorse, or a similar type of action, take the third party's communications. The SEC also expects you to have done a certain amount of review to make sure that those claims are reasonable and that they're not false and misleading. So this will be important to really require advisors to look at how they interact with third parties when those third parties talk about the advisory firm. And that could apply with respect to, those who provide testimonials and endorsements. For instance, if there's what the SEC calls in the documentaries promoters, right? Promoters who, are like lead generation firms or things like that, that provide commentary. If the advisor is involved in that content or adopts it, endorses it, the advisor can be held responsible potentially for that third-party content.
And then overlay social media on this, and then you really have some. You can really have some the challenges that the regulators already are expecting of social media when you're putting something up or somebody's putting something up, and did you like it, and all these can become entanglements and adoptions.
Yes, that's right. Yeah, and potentially including if your employees provide personal through their personal social media accounts, references to the firm's services and things like that. So things to be careful about. Why don't we discuss some practical tips that might be helpful as we're thinking about coming into compliance with the marketing rules? John, do you want to start, or do you want me to sort of, we can go back and forth?
Why don't you start, and I'll hopefully we will continue to be able to fill in the gaps.
Yeah. So one of the really important things is to consider the need to change your compliance policies and procedures to incorporate these new requirements, right? By and large, most advisory firms have a pre-approval process with respect to their marketing materials that requires a CC or somebody to approve those materials. But now, because the definition of an advertisement has changed, the requirements relating to testimonials and endorsements, including disclosures, oversight, and disqualification provisions have changed. Now we've gotten rid of the cash solicitation rule and folded it in here. And now we have new performance, presentation requirements and things like that. It's critical to revisit those advertising policies and procedures and make sure that they're updated before taking advantage of the marketing rules opportunities.
Sure, that's music to a chief compliance officer's ears. Also, there are and again, both the policies and procedures and the related, there's some specific requirements in ADV. Richard, you know them better than I do. There's actually some specific questions that change. So the people that do your ADVs have to go through and say, okay, we now need to, here's a different question or a new question. And then the description in that document. And look, I've been around a long time, and I've seen there's as we went through a spate of enforcement actions, there's some 12-page ADV disclosures up there. I don't recommend them. I think what you want to use that ADV and your procedures really as your protection, so you can demonstrate to the SEC, this, and then especially you can demonstrate to the SEC what you told your investors about this and these conflicts. I've always marveled at when people said we don't want to put this in there, I don't want to put that out there, but anytime there's actually an investor issue or complaint, or especially with a regulator, you really want to be able to point to a fulsome disclosure that's tailored exactly to your practice. It's your absolute defense for a lot of things, and you tailored the right way, it can give you a lot of flexibility.
Yeah, John hit on a good point. Form ADV is going to be amended so that the staff is going to ask additional questions in part 1 about your advertising practices. And why are they doing that? Because that gives them visibility into what folks are doing, and that informs their risk-based approach as to who they will look to examine. To be sure, because the staff is updated Form ADV, this is going to be an area of focus for the staff. Now, the good news is that that Form ADV requirement doesn't come into play until, for most folks, their annual updating amendment in 2023, right after the compliance rule. The marketing rule comes into, you're required to come into full compliance with the marketing rule. But I think the broader message is this will be an area of focus for the staff. And so make sure that those things are buttoned up.
When you talk about a sort of a practical tip, I mean, that one of the actual changes used to be the solicitor had to deliver your ADV for you, and you had to get things back, and there's a lot of forms that you got back to kind of tie that all in a bow. The rule is relaxed now. Richard can talk about that. It's actually relaxed a little bit, but at the end of the day, you probably want to be in the same place. You really want to make sure you're comfortable with what disclosures were given, to your clients or prospects. So you want to balance, hey, this is a potential benefit or something that I maybe no longer really have to do, but what's a really good business, a good sound business practice to protect my my franchise.
For sure, yeah, John's right. Another practical tip is that if the rule doesn't apply only to your marketing materials that you create going forward, they will also apply to any existing materials that you continue to use. So firms will need to evaluate any existing materials that they use and to ensure that they will come into compliance with the new marketing rule when they decide that they want to come into compliance with that rule. So that's important to take stock of those things, whether RFPs or websites, other things. So you need to make sure that those things are updated.
Such as quarterly performance reports.
Well, quarterly performance reports are a little bit different. So the SEC, and this has historically been the case, but it's now put in the marketing rule that if you're providing only updates to your existing clients about their performance and what they do, and you're not selling them new services, new products, things like that, technically those communications are not considered advertisements, right? You're not really promoting. You're trying to sell your advisory services. So technically, those are not subject to the marketing rule, but they are still subject to the Advisors Act and anti-fraud rule. So you got to make sure that they're still not false and misleading. One other thing to note about the marketing rule, and this is an important piece, is that technically speaking, the marketing rule now says that in order to prove or to generate liability, you don't have to be seen as having intended or that you willfully violated these rules. Simple negligence in these rules will actually be sufficient in order to trigger liability. So that's important. That's an important piece. Maybe it seems like kind of nuanced right now, but the explanation, I accidentally did this, I didn't mean to, may not be sufficient to avoid a problem.
Yeah, you don't want to get into a problem with the SEC and arguing about what this was or did intend or not intend. That's why you want to be as proactive as you can to start and have those great, just, you know, everything we talked about practically, but I do agree with Richard, the SEC standards on willful and reckless and whatever, you don't want to go, you don't ever want to, you know, be in a position where that's what you're arguing about.
And on that note, I wanted to open up the webinar for questions. Now, some of you have been chatting in. So far, we've had everybody on mute, but we're actually going to open it up. So if you want to actually speak with the panelists, you can unmute yourself and ask a question now. And I also just want to give you the 10-minute warning that, actually 9-minute warning, that at 1 p.m. Eastern time, this webinar will be terminated. Or earlier if there are no questions.
There's a great Saturday Night Live where I forgot who it was, couldn't get any questions, so he started saying, and boy, I really like dead kittens. So he was trying to drum up some support. I don't know if everybody remembers that one.
The first thing is, does anyone have any questions about why I have blue hair on this webinar? Why not pink? Questions like that, feel free to ask me questions about my blue hair if you don't have any compliance or legal questions.
I have a question.
I don't know if it was L'Oreal. It was the dye. Anyways, go ahead. Who has a question?
Yes, I'm Don Schellhammer. In the past, mutual fund companies, we've been able to use hypothetical illustrations with current disclosures. It sounds like any type of hypothetical illustration is going to be pretty much difficult to use or so expensive to use, just from a compliance standpoint, that it's really going to go away.
I don't think that's right. I mean, I think if anything, they've made it a little bit easier. And now, obviously, it will depend from firm to firm in terms of what that hypothetical performance looks like, in order to present it in a way that actually makes sense to people. And also, you know, part of the consideration definitely is who's the target audience, right? The institutional audience, you're much more likely to have some flexibility and leeway, as opposed to retail audience where the staff will expect more.
Right, and I think I think the funds previously, you know, under the guidance and under the new guidance, it's really going to be, there really will be a test of, you know, why are you selecting and using hypothetical performance? What period have you selected? So all those principles that we talked about, you know, fair and balanced and not misleading, you know, they're going to come into play. But the underlying understanding in the SEC, you know, allowing these is that it is actually asked for, you know, quite often. It's asked for, you know, how would you have performed in this market or things. So I think the SEC is recognizing that.
Yeah, I think one of the things that oftentimes I see that is not quite fulsomely discussed in hypothetical performance presentations is making sure you lay out all the assumptions, right? Putting the assumptions out there and letting people sort of, you know, if presuming if they could reverse engineer sort of how you got to where you are, it is important just to make sure that that information is disclosed.
Okay, we got another question here. Okay, that's just pertaining to the last point that we made. So folks, I just wanted to mention that this is the contact information for the panelists here, Andrew.Lippman at Capital Forensics, John.Ivan at capitalforensics.com, and Richard at richardchen.com. That's how you reach the panelists. Now, also, one other little thing is that some of you are following me on social media or my newsletter. I do have access to some exclusive content of mine pertaining to how to get leads and new business using LinkedIn. And this is how you would this is how you would find out about it. It's right here on my website. So please do consider that if you're, looking to build your business here in a, fun way. That's what that membership is really about. And I just wanted to also show for the second time, some of you that came on, the disclaimers. Remember that, again, this is not legal or compliance advice. For that, you would really want to consult with the gentlemen here that are giving this webinar, or your own legal counsel. And the other thing is that this information may change. We are not regulators and we don't create these rules. So we are, nothing is guaranteed to be true in the future because things do change. So please be mindful of that as well. And I just also wanted to say that, I'm just going to put it back to how to reach these folks here, that one thing I'm a little concerned about is I know that there are a lot of you that are doing it yourself when it comes to compliance, especially like some of these kind of like firms have been in the business like 30 years or so, and it's just the advisor and an administrative assistant, and the person is just doing self-compliance. I'm really worried about that kind of a situation because I've felt that with the standards so lax, a lot of you are just getting by if you're in that scenario. And the SEC can be pretty brutal to deal with. And once you get on your radar screen, they never really take you off. So I just would encourage all of you, if you haven't worked with an outside counsel before or obtained a legal or compliance advice, please do not attempt this on your own. It probably won't be worth it. And, I'm not saying that, although these are excellent experts in this area, I would never say that these are the only experts, right? There are other people that certainly do advise on these matters. So whoever it is that is going to do the job for you, find someone that can do it for you, but please don't attempt to legal or comply on your own. I just think that complexity is too steep here with this new development, and I'm worried.
I scripted that for Sarah.
I'll be the voice of optimism. I think that this landscape will continue to change. We will continue to see guys from the SEC, but there are opportunities here, right? And disruption breeds opportunity, right? And so with the proper guidance, I think that advisory firms will be able to do something that a lot of other firms have been able to do for a long time, right? In other industries, right? Which is basically get a sense of what you have your clients said about you. I get asked that, all the time when I have prospects. What do your clients have to say about you? And can I talk to them, right? So this is a good piece for advisors. It's a good thing for prospective clients too. So take that, it's a balance thing, right? Beware of the risk, but this is good news.
Okay, so listen, everybody, that's it. I'm ending the webinar now. I'll email out a replay, and I hope that all of you by now have joined my newsletter list if you were not already on it, because then you'll be receiving the replay. So thank you so much, gentlemen who have been part of the panel, my excellent resources here. Thank you so much. And everybody, thank you for, people are saying thank you in the chat, by the way. Thank you all for being here. Remember, Sarah G got your back, so make sure you get on the newsletter, follow me on social media, and don't be a stranger. Any questions, I love to, in a fun and irreverent way, answer all of your questions and maybe make some jokes a little bit. So shoot those questions at me any way you can, folks. I'm ending the webinar now. See you later. Bye.